You get full credit. You get full credit on the closed caption. If you want to hit the closed caption show captions button, it should. And if it doesn't work, you're gonna have to talk to Zoom because it's out of our control. But we're gonna go ahead and get started. I think we're okay to roll here, Beth.
Yep, all
Cameron
good.
said everything was going good on her end. So if anybody has any questions, again, put them in the chat. We can't see you or hear you, so we are not ignoring you. If you're making faces or waving at us, we can't see you or hear you because this is a webinar, and the only way to record with a group this big is to use a webinar. So Beth and I will just laugh at each other's jokes and then hope that you're laughing along at home. Okay. So you've been named in an estate plan. That's the title of our class today, and we're gonna hope. Rolling. I am rolling. You know that. Sometimes takes a second.
There we go.
There we go. That's me. Okay, that's me. I have a BS in Broadcasting Management from Northern Arizona University, and I have a law degree from the University of Denver. So that's it. I was gonna wear. I thought, well, what shirt should I wear today? Because it's CU. No, yeah, CU, CSU, Air Force, UNC. I don't know if they all play today, but I've got all those options. So I went with Vermont hockey. It seems safe, not to make anybody mad. But hope you all enjoy your beautiful Saturday once you're done learning here. So, Miss Beth.
Good morning, everybody. I'm Beth Mitchell. I went to Drake University for undergrad and DU for law school. I also have a law degree. I had to crack up a little bit when Erica said that. I was like, oh, well, that's good to know. We've only been practicing law together for 23 years. So I'm very relieved to know that Erica also has a law degree.
I do. It's on the wall.
That's excellent.
Yes. Assume it's real.
And
Where's
both
Drake,
Erica and
Beth? Where's Drake, Beth?
Oh, well, Drake is in Des Moines, Iowa. Go Bulldogs. Drake relays. And I miss my friends in Des Moines, um, but Colorado is home. So, and I should also mention that both Eric and I are members of the American Academy of Estate Planning Attorneys, which means we have to get about 3 times as much education as most attorneys do just to keep that membership. So they tried to keep us on our toes to make sure that we stay up to date on all the new stuff that's happening. We're going to talk with you a little bit about some of that today.
Excellent. Thanks. I think Des Moines is a really cool town. We drove through there this summer and I saw the Drake sign, Beth. I didn't have time to get a picture, but I thought of it. We are on social media. Cameron again keeps us up to speed, keeps you up to speed through Instagram, LinkedIn, Facebook. We don't overpost, but we do post some pretty good stuff. Cameron is real good about not let me say it this way. She puts stuff that is important, right? It's not just hey, it's National Chocolate Cake Day or whatever. So keep an eye on that stuff if you want. We do not tweet. We will not be tweeting. You're welcome. Ground rules. Questions should go in the chat. There's a Q&A also box, so we'll keep an eye on those. I think we can do that. We will probably just take those as we go. And if we can't get to them, then we'll get to them. We'll get to them. So I'm going to start out, and then we're going to bring Beth back in, and maybe Gus the cat if he's up by then. So we're going to talk now about kind of the life cycle of an estate plan. And when we talk about an estate plan, I think it's a lot of people will say, probably to you too, Beth, I don't have an estate, so I don't need an estate plan because it conjures up visions of like huge money. But an estate plan is really just a group of documents, and that's what we're going to talk about today. So we have the kind of life cycle of that while we're healthy, if we get ill, and when we pass away or when we die. Okay, right. 9:05 on a Saturday, and we're going to talk about dying. We do understand that's not everyone's favorite topic. We try to handle it with respect, but still, we quite frankly try to handle it with a little bit of sense of humor just because we have to talk about this every day, all day for the past 20 plus years. And so I think that might be a defense mechanism as well, but it's just not everyone's favorite topic. But it's an important one, really important. So thanks for joining us today. Even if your parents said, you know what? You need to sit and watch this on Saturday morning at 9:05. The good news is we used to drag you to the library, right, Beth, and make people go there and eat Danish and drink coffee. But
We
now at
did give
least
them
you can,
treats.
and we
We
did
gave
buy them good
treats.
treats. So now you got to buy your own treats, but you don't have to go to the library and go out on the roads. Hold on, I'm trying to get it to listen to me. Okay, so during the good years, your estate plan is standing by. No, it's there. It's a bunch of paper, quite frankly. It's kind of a weird thing. You're like, oh, I'm going to pay this money for this estate plan, and it's just going to sit here, and I hope I don't need it for a long time. But that's exactly what you do. That's what it does. Is it sits there. Okay. You want to keep your plan up to date. That would be a review. It's not that you have to change your plan all the time. It depends. But you should probably review your plan every 5 years or so. But and we are, again, if you get our client, we're going to send you emails if things change in the laws, and so you're going to get that information pretty much through us. Sorry, I'll get this to like me. If you become ill or injured. So let's say you become incapacitated, and we don't know if this is a week or a month or a year, but there's no one on, if you don't have an estate plan, there is no one on the earth with the power to be able to sign things for you. Absolutely no one. People often have a misperception that their spouse can just sign things for them. And I mean legally, not forging, okay, people. But your spouse does not have the legal power to sign things for you just because you're married. What do you need? You need a general durable power of attorney. We call ours the property power of attorney. Same thing. If you don't have one of those and you become incapacitated, someone in your family is going to have to go to court and get appointed by a judge and do a whole thing called a conservatorship. And that is a big pain. It's doable, but it's a big pain. So that's why we do general durable powers of attorney, or what we call property powers of attorney. And in those powers of attorney, if you're our clients, one of three, it'll say, when is this power of attorney effective? And it's one of three times. So you're appointing people you trust to handle your financial affairs during your incapacity. Some of the powers of attorney say it's effective immediately. As soon as you sign it, the person you appointed can sign things for you. Some say it's valid only upon your incapacity. So in our power of attorney, it says, if it's valid upon incapacity, it says one doctor has to say in writing that I am no longer able to handle my financial affairs, at which point the person I've appointed, my agent, can sign things for me. So if it's valid upon incapacity, a good power of attorney is going to say, what needs to say, how do you prove that? We've gone to one doctor because it's kind of hard to get two doctors to do anything. I'm not blaming the doctors, I'm just blaming the processes. Okay, so most of ours, unless they're really old, say one doctor. Okay. And so what is going to be needed for my agent, if I've appointed Beth to make my financial decisions, but she needs to prove I'm incapacitated. Beth, if you call my doctor and say, or show up wherever I am and say, I need a letter that says Erica's incapacitated, what are they going to say to you?
Well, yeah, if I walk in and I say I'd like Erica Johnson's medical records and I'd like to know if she's incapacitated, is she crazy or what? I would hope that they'd say, I'm sorry, we can't release that information to you.
Why can't they?
Well, there's this fun law called HIPAA, passed in 2004, and it's great in theory, but the problem is that when it is a situation where Erica has truly gone round the bend, I'm going to actually need to get access to her information to be able to manage things for her, which means that I have to be able to talk to the doctors and they have to talk to me. And the thing about HIPAA is that a lot of times you kind of can fall between the cracks and people will release information to you. But if you run into somebody who actually knows what they're doing and they're going to enforce the law, they're right. And they get fined if they violate HIPAA laws. And so you have to have that HIPAA release so that there's a free flow of information.
Perfect. And so all of our clients have a HIPAA release. It is in your binder. It's under medical or healthcare documents tab, and it says like authorization to release protected health information. That's your HIPAA release. And so That's an important one. Now, I've talked about a power of attorney that's effective immediately upon incapacity, and some are a hybrid. They say, as to my spouse or partner, the first person I've appointed, it's valid immediately. They don't need a doctor's note. But as to my backups, if my spouse or partner can't act and we're going to my backups, that person has to have a doctor's note. So we talk through that with everybody and let them choose. Okay, what's a durable power? Well, a durable power of attorney just means it's effective while I'm incapacitated. If it's not durable, it would say this is no longer effective when I'm incapacitated, which defeats the entire purpose of the power of attorney. So I have seen people get powers of attorney off the internet or something, and right there, page 6, it says this isn't valid upon my incapacity. So all of our powers of attorney are durable. They're valid during your incapacity. Okay. And again, this prevents a conservatorship or a court process being necessary. That's what a power of general, durable, or property power of attorney does. Okay. So the next one is to use this financial or general power of attorney. Your agents, that's the person you appointed, must have the original. They can be asked for the paper. So what do we remind our clients a million times? Tell your people you appointed where you're storing the documents. They shouldn't give the original away. And our clients have 2 original financial or property powers of attorney. We have you sign a short one and a long one. They do the same thing, but that way there are 2 originals. Okay, and we're going to cover a little bit later about do they know where stuff is and all that. But make sure that the people you've appointed know where all your documents are, and they can get to them. It's kind of, don't put them in the safe, and they don't know how to get in the safe. HIPAA release, we just talked about it. Can they get your medical information? Can they talk to the doctors? All of our clients have one of those. It may have, if you've moved, it may have an old address for you, but that does not make it invalid. So you don't need to write on it. Don't write on any of your documents once you've signed them. The ones you've signed. Okay, there are some things in your binder that are designed for you to fill out. But when you have signed something and it's notarized and some of them are witnessed, writing on it essentially invalidates it. So you don't need to worry if your address is incorrect on your HIPAA release. We don't usually suggest that you pay us to do a new one to change the address. That would make us more money, but it's not necessary. So we don't do that. So you've got a HIPAA release if you're our client. And we're going to talk in a second here about making sure that those are accessible if there is an emergency. Medical power of attorney. Okay, well, who makes my medical decisions if I can't? If I don't have a power of attorney, Colorado law says if I get hurt and can't make my medical decisions, all interested parties in my life are supposed to get together and agree who's going to make my medical decisions. And you can imagine that is not working well in a lot of situations. Having everybody, all interested parties in my life, which is a whole lot of people under the law, I'm not going to get to the list, agree on who's going to make my decisions isn't really safe. What we do is we do a power of attorney that says this is who makes my medical decisions. So no one has to go to court and become my guardian or fight over who's going to do it. And usually hospitals will honor a copy of a medical power of attorney. Again, financial institutions generally won't honor a copy of a financial power of attorney, but medical, they often will. Sometimes they're faxed to the hospital. Yes, there are still fax machines in hospitals. Okay. And the question, how do these documents work when you have an adult child that is disabled? Both my husband and I are his legal guardians. He can't likely sign his own documents. You, as his guardian, make his medical decisions. You, as his conservator, would make his financial decisions. So he doesn't need a power of attorney because he has a guardian. Your adult disabled child. Okay. Yeah, Beth, we are only licensed in Colorado. Thank you, Beth. So that's medical. Now, how do we make these things accessible? My medical power of attorney, my HIPAA release, in an emergency. Well, a lot of us use a company called DocuBank, and we gave you information about that when you signed your documents, most likely, and you maybe didn't follow up, and this isn't required. It's just something we've seen work. So if I need immediate access to living will, HIPAA release, last remains declaration, and my medical power of attorney, I'm hurt. They haul me off to the hospital. They're looking through my wallet to see who I am. What will they find? My wallet is now in the back of my phone. I finally got talked into that. So the first thing on top of my little phone wallet is my DocuBank card. It says, call this number or get online and you can get my medical directives. So yes, if you found this on the sidewalk as I was walking my dog and I dropped it one day, you could get my medical directives. Do I care? No, I don't care. It's my healthcare power of attorney, my HIPAA release, and my living will. It's not meant to be secure. It's meant to be accessible to anybody at the hospital who finds me in an emergency. Okay, or I show up there. And they will email or fax the documents over. And now they have, my family does not need to go to my house and get my medical directives and get to the hospital. They can go straight to the hospital. So DocuBank is kind of a cool thing that a lot of our clients will use. Okay.
Erica,
Yes,
do those medical powers of attorney or HIPAA release, do those have your social security number or any of your protected private information in those?
nope, they don't. You know, the HIPAA release has my address probably, but my address is readily accessible on the internet, among other things. So no, they have, it has nothing private except how long I want to stay on life support if I'm terminal and who's supposed to be making my medical decisions. So I honestly did drop my card on the sidewalk walking my dog back when I lived in South Denver, and the lady calls and she says, I have your, actually she called Carrie because Carrie's listed as my contact. And she's like, I have this DocuBank card. Well, what if the lady had gone in her house and called and had them send over my medical power of attorney and my HIPAA release? I don't care. There's nothing on there. I don't think she did, but anyway, she could have. This is not my financial information. Okay. So DocuBank is kind of cool. There's also what they call it, DocuBank, the ICE program. In case of emergency, that takes on, anyway, case of emergency for college students, your kids are in college, they get hurt, they should have a medical power of attorney, a HIPAA release, a living will, and a DocuBank card. And if their DocuBank card is accessed, or their documents are accessed via DocuBank, DocuBank will notify you, the parent. Hey, your son's, we just got the hospital asking for your son's medical directives. Okay. So that's something to think about. Can a hospital refuse a medical power of attorney? No, except they can require the original to be shown. So in most cases, and I haven't seen that happen, where they won't honor the copy that comes over from DocuBank. Have you, Beth? No.
It had to happen once about
Okay.
15 years ago.
Okay.
The family was fighting. And so, the hospital's they concerned about liability, but once in 24 years.
And at that point, somebody went and got the original and came back and showed who was in charge. So, yeah, thank you. Okay. What if you're dying? Organ donation. In our medical power of attorney, we have a section that lets you say whether you want to donate organs or not. For transplant only to an immediate family member. For research, and our clients make that decision. Now, if you have it on your driver's license, if you look at your driver's license, there's a little, if you are a donor, you have given what they call first person consent. There's a little black heart. I have the old ID. Little black heart somewhere on your license with a Y in it. It's harder to see the older you get. It used to be red, but now it's like, what is that little thing? Well, that's saying, yes, I'm a donor. And
why did they change the heart from red to black? That seems a little
black heart. I know. And well, they changed this whole ID to black and white.
You're right.
No color on that anymore. So I don't know why. You have a black heart. So I am a donor. If my organs can be used upon my death, and boy, you really got to die the right way for most of your major organs to be used, meaning you got to die on a respirator. my family technically can't say no to that. Now, the Donor Alliance generally asks people because they don't want to be making people mad, but I have given first person consent. It's on your driver's license. Okay. And if it's on there and you want it off, you're going to have to call the donor. There's a number. Google it. Google it, kids. It'll show you where you can get your name taken off of that. So what is the third medical thing that we do? We do a medical power of attorney, a HIPAA release, and a living will. The other term for living will is an advance directive. It is my directive. So what is a living will? I am directing myself. I'm not appointing anybody. What to do in two situations. Now, when we start talking about medical stuff, I will tell you that 90% of people start talking about, oh, they're going to have to pull the plug, and who's going to pull the plug, and my brother's going to pull the plug early, and my kid's never going to pull the plug. And most of us, and I'm not saying none of us, most of us don't end up on a respirator, i.e. the plug. It is TV shows and movies. Everyone's on a respirator, I guess, because then they can show them on the screen. But most of us don't end up on a respirator. If we do, our clients have a living will, i.e. advance directive, most of them, that says if I'm two doctors say in writing that I am terminal. So two doctors are saying I'm dying, plus I'm not responding. I'm not receiving information or communicating. So it's not just that I've been declared terminal. I'm terminal, I'm not responding, and I'm on life support, right? I have to be all three things: terminal, not responding, and on life support. Rare, unless you're in the movies, and we're not in the movies. So if that happens, my living will says, this is how long I want to stay on life support. 3 days is what mine says. I'm thinking somebody might want to visit, but I don't know. Some people have 5 days, 7 days. There's no right number of days. But that's where it stands. Okay. And then it lets me say whether I want to stay on artificial nutrition after that. No, but that's all stuff we talk through. Okay. And that's in your living will. I'm not going to get into the, we don't want to get too deep here. We won't have time for Beth, but a living will / advance directive is part of your estate plan. Almost all cases. Okay. One thing it isn't. What isn't a living will, Beth? I bet you know what I'm referring to.
You're talking about a DNR?
Yes. How do you get a DNR, Beth? If you want to, what is a DNR and how do you get one?
So a DNR or CPR directive, DNR stands for do not resuscitate. So if you want a DNR, you have to talk to your physician because it requires a physician's signature on it. And the thing about a DNR is you may or may not want one. You want a healthcare power of attorney, you want a living will, you want a HIPAA release. Do I want a DNR at this point in my life? No, because if something happens to me and the paramedics show up, I want them to still perform CPR. They could perform CPR, I could be fine, live the rest of my life. So usually you talk about a DNR when there's a terminal illness or with advanced age. Those are the times that you do put that DNR in place. But that's not something we do. You do it with your physician. And you probably will also talk to your physician about a MOST form. What's a MOST form, Erica?
MOST is a form that you get from your doctor that is in part a DNR and in part about how you want to be treated or what kind of treatments you want. You can Google Colorado MOST, MOST, and read more about it. But you talk to your doctor about that if you want to discuss a MOST form. It's medical orders for scope of treatment. And it's not something we do, and it doesn't replace the living will. It doesn't conflict with the living will. But most forms and DNRs are doctor things. And while we have doctorates, they're in Juris Doctorates. So you don't want us using our Juris Doctorate to talk to you about that. Okay, Declaration of Last Remains. Oh, more fun stuff. Okay, 25 minutes in, let's talk about dying some more. All of our clients, I would say all, have a Declaration of Last Remains, a document that says, I want to be buried, or I want to be cremated, or I want to be composted, or I don't care. This person decides. Okay, and it can set out what they want for services. We don't get too deep into the services. We might set out more what do I want done with my ashes? Where do I want to be buried? Or I don't care what you do with my ashes, or I don't care where you bury me. So that's all set out in your declaration of last remains. And I think it's important that the people you've appointed to do things, you should tell them this. Because when somebody dies, about 60 seconds later, if you're there, they say, who do we call and what do we do? And what do they want? And you're not going to remember. Even if I remember when my sister-in-law died, I had written her declaration of last remains, and I'm like, oh crap, oh crap, oh crap. Sorry, my language. I couldn't remember if she wanted to be buried or cremated. And it wasn't that long before that we wrote it. So talk about it, maybe take a picture of it because it's high stress and they ask right away. What's the safest thing to do? Pre-plan. Plan it, go pay somebody, or at least plan it with a company that does that. So in my mind, it's a gift. So after they're gone, can you find the documents? Do you know where the binder is? Or some of our clients have boxes with their originals. Okay, when we did this back in the early 2000s, mid 2000s, your originals might be in a box, a white box. I don't know what year we switched to the binders with the originals, but I'm sure you figured that out. So can they find your documents? Do they know where your assets are? Do they know what they are? Okay, because they're dealing with grief. They're dealing with it. Your brain is mush when somebody dies who's close to you, and you're not going to be thinking straight. So the more information you can have written down for your peeps, the better. And in our binder, there are some tools that are helpful for that. So there are 3 basic types of plans for our clients. Some have simple wills. They're still really long because we're lawyers. We like a lot of words. Okay. Simple
All the
wills.
words.
Yep. Wills with a trust and a revocable living trust. So I'm going to talk about wills, and then we're going to let Beth run loose here in a few minutes on trust. So simple will, or will with a trust. It distributes your estate assets, your assets, after a probate. So when I have a will and a zillion people come in and they say, I thought a will didn't go through probate. Well, your neighbors that told you that were wrong. Okay, a will goes through probate, which is fine. It's not the end of the world. I'm just saying it does. Okay, I don't care how many neighbors tell you at happy hour that it doesn't. What's the purpose of probate? It's to change the title of assets from the deceased person, the decedent, to the new owner. So let's say I own a house, and I own a house in my name only, and I die. No one has the power to deal with my house. My power of attorney. So some people say, well, wait a minute. I'm my dad's power of attorney. I could sell his house, or I'm Erica's power of attorney. I can sell her house now that she's dead. No. Power of attorney is only good while you're alive. So what happens when I die and I have this house in my name only? I have a will. Let's say it appoints Beth as my friend, not because she's my lawyer. She's not going to act as my personal representative, but it appoints Beth to be in charge. She's not in charge until a court appoints her. Okay, so what is this probate? First, what doesn't go through probate? So let's back up. My house we'll worry about in a minute. Let's say I own a house jointly with someone else. Joint tenants. We have to own it as joint tenants. No, Beth, we do not own it together. I own it with someone else, and they're going to get the house. Beth, you don't get the house. So if we own it in joint tenancy, it goes to that person. If I have a living trust, we're going to talk about that. It doesn't go through probate. What else doesn't go through probate? My assets that have beneficiaries. My IRA has beneficiaries. My life insurance has beneficiaries. And some of my assets might be payable on death, POD, or transfer on death, TOD, same thing. I might have an account that says that when I die, I want this to transfer to Beth. There you go, Beth. And then when I die, that account goes to Beth. Okay, so those don't go through probate. But I've got this house over here, and I own it in my name only, and I die.
Well, Erica, before you go there, let me ask you this.
Yeah.
Should you just name beneficiaries on all of your accounts so that you don't have to go through probate?
Maybe, maybe not. Oh gosh, I'm a lawyer. Okay, Generally, no. Generally, it's a bad idea because now there's no money to pay my bills, to handle for my final expenses, to okay. So naming a beneficiary on everything I own may not work as well as you would think. Doing a probate would work better. But it really is very specific, client to client to client. Okay. So that's where, so when do we need probate? In Colorado, we need probate if there's any real estate, real property, any real estate. Or let's say I don't have real estate and I have an account, a brokerage account with $150,000 in it and no beneficiary on it. Well, it's over $86,000. That's the amount this year. Or I have a Ferrari. I don't. I've been trying to find a client with one to let me drive it, but nobody has one yet. So if my Ferrari is worth $110,000, it's probate time. So let's talk about what probate is more than specifics about who's going to have to do a probate or not, because we got, I don't know, almost 100 people on here, so we can't really get into your specific situation. But basics of probate. You file the probate in district court. So my will says, this Beth is my personal representative. Okay, i.e. executor. And Beth, I'm not suggesting you can appoint Beth. Beth is my friend, so I can appoint Beth, but no, we as your lawyers will not act as your personal representative. Sorry. But she has to get appointed by the court to do that. So she sends my stuff down to the court. I live in Arapahoe County now. I had to think about that. I live in Arapahoe County now, so you file my probate in Arapahoe County, and you file my original will, and that's called lodging the will. And then Beth says, I need to be appointed by the judge to be Erica's personal representative. And the judge will send back some stuff that says, okay, you're in charge, Beth. So she files the petition. The court issues an order. She signs a thing that says, I'm okay to be Erica's personal representative, an acceptance of appointment. Beth, are you handling the questions or do you want me?
Hold on. I've been kind of answering the questions as we go. And
Joanne has a Ferrari. Joanne has.
I saw that. Somebody has a Ferrari. Sorry. I was going to tell you that. But I'm answering questions as we go. If it's something that I think would be really good for the whole group, I'll stop us.
Okay, thank you.
And otherwise, I'm addressing them as we go.
Yeah, if you can hit Ed's thing there, beneficiary. Thank you. And okay. Petition is filed with the court. PR signs. Okay. The clerk at the court sends Beth this paper that's called letters. It says, Beth, you are the personal representative of Erica's estate. Yay. This is the paper you carry around and show everybody that you're in charge. So you can take it to my bank. You can go and sell my house. You can go or transfer my house to who's inheriting it. And all of that is just part of the probate. Okay. Beth, my personal representative, has to notify my known creditors, my Southwest card that I use for everything, right? You got to send them a letter. But Beth also has to run a notice in the newspaper in Arapahoe County. Yes, in the physical paper still. Till we run out of them, it's still in the physical paper. And that notice says, world, Erica died. If she owed you money when she died, you have 4 months to come and get your money. And it gives a 4-month window. And it says, I'm Elizabeth Mitchell, come see me. We're doing a probate. You got 4 months. And if anybody comes forward, Beth determines if they're regular, if they're a real creditor or not. We don't see fake creditors. People are like, oh, do people come out of the woodwork? No, because they have to lie to the court to say they're a creditor if they're not. And honestly, people aren't generally going to do that. So 4 months after that, once that 4 months runs, no creditors can ever come forward and say that I owed them money. Too late. Okay. Let's say we didn't have to run the notice because I had a trust and we didn't have to do a probate. Well, 12 months after I die, no one can come forward and say I owe them money. Okay. So Beth has to do an inventory of my estate. As my personal representative, she has to do an inventory. Erica had a house, a car, a bank account. She does not have to count all of my T-shirts and my tennis shoes and my whatever. Okay. She cannot close my probate until at least 6 months have gone by, and it usually takes longer than that anyway. Now, this talks about a 706 estate tax return. Beth, good news for you. You are not going to need to file a 706 estate tax return for me because that is a federal estate tax return that it needs to be filed if my estate is over $14 million. Beth and I are not litigators, so we do not make that kind of money. We do not have $14 million. We went to the wrong kind of law. So you file a 706 estate tax return if your estate is over, they file it for you if it's over 14 million. Now, Beth might need to file an income tax return for my estate for the probate. She's talking to a tax person about that. She's going to say to the tax person, I'm in charge of this estate. Do I need to file a 1041 income tax return? If you ask us as the lawyers, we're going to say, go ask a tax person. We are not tax attorneys and we don't dabble where we should not. So the personal representative gets a tax ID number, opens an estate bank account. So Beth goes and opens an account in the name of my estate. She gathers up my assets. She pays the bills. She runs the notice in the paper. She pays the legitimate bills. And then she looks at my will and it tells her who gets it. Nope, Beth, it's not you. You get all the work. Someone else gets all the assets. Okay.
It's always that way.
Yep. And so somebody, it doesn't pay to be the responsible child in the family because you're going to be the one having this job. So do something to mess up and then your parents won't appoint you. Okay. If the will, yes.
I was going to say, this might be a good point to address a question. So when you talk about gathering the assets together, so Erica, you mentioned earlier that some assets name beneficiaries, or they might be POD or TOD. Can a house have a beneficiary listed on it?
Some in Colorado, in the right situation, I hesitate to even bring this up because it confuses people. So, but I'm going to because you just did. There is such a thing called a beneficiary deed, a deed that allows me to say, when I die, I give this house to this person. It's called a beneficiary deed. We don't recommend you go run out and get your own and do it. It should be part of a conversation with your estate planning attorney. And it would have been, and if it wasn't, then it wasn't appropriate for you. We don't bring it up with every client because it's not appropriate for every client. Okay, so yes, there's a beneficiary deed out there, like a transfer on death deed is what some states call them. And if it was appropriate to your situation, we would have brought it up in your meeting. I thought it was a hawk, but I think it's not. Okay. A will, the last one, a will might create a trust when I die. My will might say, when I die, I want to leave these assets to my great niece. I used to be able to say my niece, who is 10, but it's my great niece who is 10 now. And my great niece is 10, and AJ should not have a lot of money. And AJ's 10, so AJ can have a lot of money. But I would create a trust for AJ, where AJ's dad is in charge of it, my nephew. So that can be done within a will. You're going to, before you close my probate, Beth, you're going to make sure my 1040 was filed. You're going to ask a tax person if my estate needed a 1041 income tax return. That would be if the estate was open and it was making money after my death. You're going to deliver a final accounting, all the money in, money out. And then you're going to divvy out the assets and close the estate. So the probate process is a process. It's not used. The probates we help people with are not in court except for paper. It's a lot of paper back. If someone's fighting over it, if someone wants to go to court and argue over something, they hire an attorney, not us, because we don't do that. They hire an attorney and go duke it out. That is not as common as books and movies and TV would have it seen. Okay. A good, well-written estate plan isn't challenged in court pretty much ever. I shouldn't say never, but. So what does it cost? What does it cost to file this? The filing fee to file a probate is a whopping $199. Okay. Where does it become expensive to do probate or more expensive? When they hire a lawyer to help them. Lawyers, we don't work for free for most people. We have to charge a fee. We charge reasonable compensation, which is hourly. That's all that means. In Colorado, attorneys doing probates, helping people through probates, charge hourly rather than a percentage of the estate. Okay. And what do we charge? Again, it probably averages $5 to $7 grand for a probate process. Some states use a percentage of the estate, California, New York, I don't know what others. But if the person you've appointed does not have to hire a lawyer legally, they don't have to, they can do it on their own. If they do hire a lawyer, then the lawyer is going to charge. Okay. Now, last thing I think here, before I get to Beth, we get to Beth, out of state real estate. I own a house in another state. I die. Beth is my personal representative appointed by the Colorado court. Can she deal with my property in California? Not until a California court gives her the power. So she's going to need to do what's called an ancillary probate in California, where my other house is. Okay. Or what did I say? I used to say Nebraska all the time. I don't know why I would do that. But any other state, she's going to have to do an ancillary probate. So that process is the process. Okay. And it's the process that a will goes through that might be advantageous because after the notice runs, actually the bars, there's no creditor claims can come forward. The best thing about a probate is really that in order to do a will, you pay less to have the will set up than a trust. So Beth's about to talk about trusts. Those cost you more to set up with the lawyer when you do the plan than wills. And some people want to pay less for a will, and then the probate is gone through when they die. That's fine. It's not a right or wrong. Probate is a public process, so if you're, if you don't want someone to be able to see your will or know what's going on, then you really don't probably want a will or a probate. Okay. All right. So hopefully, yeah, I think I left you enough time here. We got till 10:15. So Beth is gonna talk about trust now. So wills with trusts, and now we're talking about trust.
Perfect. Thank you. And I think I got everybody's questions answered. There was one question that came in by email, and I'm going to address that as we talk about trusts, because it was a question about trusts. So,
Okay.
as Erica said, when we sit down with clients, we're trying to figure out what type of plan works best for them. And our role is primarily to educate. And that's why we talk with clients about wills and trusts and the differences between those. There's no right and wrong. Some people do wills, some people do trusts, right? And so what we're going to talk about, Erica's talked about wills and the probate process. We're going to talk about the other side of the coin, which is trusts. When you do a will, right, it generally, like Erica said, less expensive to set it up. The cost comes and the work comes really after your death. A trust is just the opposite. When you do a trust, it does cost more to set it up now, right? And you're going to do more work now. That reduces the cost and the work later, right? So it's just how you chose to deal with it. There's no right and wrong. Everybody just does things differently. So when we talk about a revocable trust, and there are different kinds of trusts. There are irrevocable trusts, there are charitable trusts. We're talking primarily about revocable trusts, which is what 99.9% of our clients would have, because a revocable trust is a tool that's used to control assets both while you're alive as well as after your death. And when we are creating trust for somebody, we look at their situation. Is it a married couple? Is it a couple in a civil union? Is it an unmarried couple? Is it a single person? And so there are different types of trusts that are tailored for all of these different situations. Now, one of the big things when you look at your trust is you have to figure out, did you transfer the assets into the trust? Remember when I said you're going to do more work now when you set up a trust? That work is transferring the assets into the trust. It is critical that if you set up a trust that you actually transfer the assets into the trust. Because remember when Erica said that when you die, if you have $86,000 or any real estate in your name, that you have to do a probate? Well, if you don't transfer the assets out of your name into the trust, then you still have to do a probate. And one of the reasons you're setting up the trust is to avoid probate. And so the key is to transfer the assets into the trust. That process is called funding your trust. And in our documents, you'll see a document that's called Living with Your Living Trust. And it basically explains how to transfer the assets into the trust. If you own real estate, most likely we prepare deeds transferring your real estate from you to your trust. If you have investment accounts, we likely would have told you here's how you need to either title the account or how the beneficiary should read on the account. With cars, boats, high value things, that kind of thing, there are also ways to transfer those assets into the trust. One note I will say here is one of my favorite things that the state of Colorado has done in the last several years is what's called a transfer on death form for vehicles. It's basically naming a beneficiary on your car. And you can fill in that form and say, when I die, I want my Ferrari to go to Erica. She'll be so happy. I want my Ferrari to go to Erica. I fill in that form. It doesn't even require a notary. And then I put it with the title to my vehicle. And at my death, then she can take that with my death certificate down to the DMV and they'll transfer the title over. Anything that makes things easier at the DMV, I am all in favor of. So that form is available online. You can go to the Department of Revenue website, or you can search Colorado DMV and search, a vehicle transfer on death or TOD, and you can pull that form. It's very easy to do. So basically, when we sit down and do a trust, we're going to go through the list of assets that you gave us in your questionnaire and try to make sure that everything gets into the trust. That's why we ask for that list of assets from you, so that we can help to coordinate all of that. And then, of course, we also want to make sure that the beneficiary designations on IRAs, 401ks, annuities, life insurance, that all of those things are set up correctly as well. So we'll make recommendations as to how those beneficiaries should be set up. That is very individualized, especially when it comes to retirement accounts. There are a lot of different tax ramifications for how those pay out. And without boring everybody about tax law under what's called the Secure Act, which Erica and I find fascinating, but you might not want to sit through a tax lecture on Saturday morning. It is important. So we would have made very specific recommendations as to how beneficiaries should read on all of those accounts. Somebody said bank accounts. Yes, again, all the accounts, we're going to make recommendations on how those titles should read, if you should retitle them, if you should do a POD. We will talk to all of our clients about that. And you should have funding instructions in your trust that cover that.
In your binder.
Sorry, yes, in your binder. Thank you. There we go. Okay, so this is a really basic analogy, but I always use it to talk to my clients, and that is think about the trust like a box. I feel like I'm talking to 5-year-olds, but I know. Think about it like a box that you put your assets into, right? So the way you put your assets into the box is by titling them in the name of the trust. So the house gets titled in the name of the trust, the investment accounts get titled in the name of the trust, and then there are some assets outside of the trust, like your bank account. You might name the trust as the beneficiary, or your retirement accounts, you might name the trust as the beneficiary. The goal is that everything is set up in the trust. Okay. Again, what you're doing is you're doing the work ahead of time so that if you become incapacitated, it's done. It's already in the trust. Now, Erica talked about powers of attorney. A general power of attorney allows somebody to step in and manage your assets if you're incapacitated. But if that asset is titled in the name of the trust, then your trustee would manage it if you become incapacitated. Okay. So that's why we also want to try to coordinate all those documents to make sure you kind of have the same people doing the same things, because otherwise it can get really messy. Let's say that Erica names me as her trustee, but then she names her sister as the agent under her power of attorney. And maybe I like her sister, maybe I don't, but we then have to figure that out together and coordinate. And that can just make things more difficult. So that's another conversation that we have with all of our clients. So if I become incapacitated, whoever I've named as my successor trustee has to step in and take over, and they manage everything that's in the trust for my benefit. So if I name Erica as the trustee, Erica, do you get to just take all my stuff?
No. My job
No.
is to do what's best for you, Beth. But
Yes.
Uh, and I'm pretty sure you can trust me to do that. If you didn't, if you had an inkling that I might use your money or your assets for my benefit, should you appoint me?
I guess probably not. Probably not. So if I have a Ferrari that I know Eric has been eyeing, I
Don't.
may not name her. Maybe I should name somebody else who I think would maybe, not be driving my Ferrari around if I'm incapacitated.
All right. No fun.
I trust you. I trust
Okay.
you. So the
Especially
other
since you
thing
don't have a Ferrari.
I know, yeah, I guess that's probably a key point there. The other thing is I want to make sure that they have the little cards that we've done for everybody. So in your binders, you should have a card that says the name of your trust on it, and it says you've been named as a successor trustee of the Mitchell Trust dated blah blah blah, right? Give those cards to the successor trustees so that they know that they've been named. It also has the correct name of the trust on it. And then on the flip side is our card, the attorney that did your planning for you. That will help too because that way they know how to get a hold of us. They should also, of course, know where you've kept your documents and all of that so they can get access to that. But all of this is to try to tie this together, right? It shouldn't be a mystery, who's in charge and where your documents are and all of that. It might seem very self-explanatory to you, but sometimes connecting the dots can be harder than you think. So the more information that you give to people, the better. People used to never talk to their families about estate planning, and what we have learned over the years is that didn't work very well. It works a lot better if you talk to your family about, who's actually going to be in charge and where you've kept your documents and where your accounts are. I'm trying to, there we go. Okay, so let's say that Erica is now the trustee of my trust. I'm incapacitated, right? And so the trust document actually says she's going to step in, manage all the assets for my benefit. So even if I do have a Ferrari, she's not going to transfer it to herself and drive it around. She's going to safeguard those assets for me. And if I have people who are dependent upon me, the assets might need to be used for them as well. Sorry, I'm
Sorry,
fighting
I'm
with
having
the
my coughing attack as usual. Uh, Someone's asked here if I'm your trustee and you have debt, uh, and you have nothing, do I have to pay your debt?
mm. So I have nothing at my death, but I have a whole bunch of debt. Well, let's hope that that doesn't happen. But if it does, we don't have debtors' prisons like they did back with
Oh, good.
and back in England and all of that. So the only debt that you pay is based upon what the assets I have. You do have to use my assets to pay my debt, right? Whether it's taxes or anything else, that does get paid first before the beneficiaries get anything. But my beneficiaries don't have to then continue to pay my debt for the rest of their lives or anything like that. Once I've gone through my assets, then that's it. And the beneficiaries will get paid based upon what I do have at death. But if I do have substantial assets, which hopefully I do, especially if I have my Ferrari, then more than likely you're going to just pay the debts. All right, so this is a little diagram that looks at kind of a life cycle of a trust. And this would be generally, I would say, a married couple's trust. Let's call them the Smiths. And so you see that little box up at the top, right? So this is the Smith Revocable Trust. During that first phase of the trust, they go to their attorney, they set up their trust, they transfer everything into the trust like the good clients that you all are, and then they just live their lives. Nothing is any different. They manage their assets however they would like. A good way to think about a revocable trust is the same way that the IRS does. So the trust is a transparent entity during your lifetimes, which means that the IRS and everybody else is basically going to pretend that it doesn't even exist. So you don't file any different tax returns. You don't have to ask anybody for permission to do anything with your assets. It's yours just as if you didn't have a trust. Then, at the death of the first spouse, right, everything still stays in a trust for the benefit of the surviving spouse. And at that point, this we would have set up the trust and set out the rules, right? The surviving spouse is probably the trustee of that trust, and the trust document will say, does the spouse have the right to do whatever they want to with the assets? Is it limited? And so this is where the trust document is really important because it lays all of that out. And it's not the same for everybody. Some people are more limiting, some people are more there are no limits with the assets for the surviving spouse. So generally the surviving spouse then lives out the rest of his or her life using the assets in that trust. And then at the death of the surviving spouse, now it's going to split to whoever they designated as their beneficiaries. They did that together, way up at the top, right? So those beneficiaries have been set at that point, and they will have said how the money will pay out to them. So in this scenario, just to make it easy, right? Let's pretend that those are their children, right? So they would have said, okay, at the death of the second of us, everything goes 50-50 to Bob and Mary, or maybe they like Mary more than Bob, so it's 60-40. Whatever it is, they will split the assets out at that point, and there will be rules for how the assets will then be distributed to those beneficiaries. So you basically just follow the rules of the trust as you go through this. Now, I will just take one step back here and say this. The trust is definitely not a how-to manual. It doesn't say do one, two, three, four, right? And so the number one thing that I encourage you to tell all the people that you've named as trustees is that we don't expect anybody to know how to be a trustee. It's not self-explanatory. People don't just come magically with those skills. And so your trustees should know they're not in it alone. They can come to an attorney for help, whether it's us or somebody else. Of course, they'd probably rather come to us because we're more fun than the other attorneys, but they should come and get help and understand what they're supposed to do because people don't know what they don't know. And what we'll do is we'll sit down with them and tell them what needs to happen at that point. Okay. So the trust document will say at the death of the trustor, the person who sets up the trust, what's supposed to happen. And at that point, whoever you've named as the trustee has to create an administrative trust, which is just a fancy way of saying that they have to pay the bills and file the taxes. Remember the two things that are sure in life, your death and taxes. Right? So even though you're dead, the IRS still wants their cut. You have to make sure that those taxes get filed. And then everything is paid from the trust, right? So your beneficiaries aren't personally responsible. They're going to pay those bills, pay those expenses from the trust, and then that administrative trust is ended. The difference here between when you do a will and a trust is remember, Erica talked about when you have a will that you have to file that notice to creditors in the county paper and you have to give them 4 months to come forward and present their claims and all of that. With the trust, there is none of that. There's none of that publishing or anything. Okay. Does that mean you don't have to pay them? Of course not. They still get paid. It's just a more streamlined process. The one of the things we get lots of questions about is about your tangible personal property. And so I like to use the technical legal term stuff for your tangible personal property, but what we're really talking about here is your furniture, jewelry, family heirlooms, collectibles, artwork, firearms, your toaster, your socks, it's your stuff, right? And some of us have very valuable stuff, some of us don't. I will say I've seen definitely a trend in that people used to be a lot more concerned about their stuff, and these days it's more of a battle to get somebody to take your stuff, right? Most people don't want my toaster. They have their own toaster, right? I think my toaster is fabulous, but they don't want it. So, but in your documents, what we've given to all of our clients is a personal property memorandum. And that's a document that you fill out later. This is one that you can write on. This is one that you fill out where you would say, my toaster goes to Erica. My Ferrari goes to Erica. My
Good.
all my valuable artwork goes to so and so. My, all of that. You can make that list and you can update it and change it throughout your life whenever you want. That's not something you do through us. You don't even have to use the form we've given you. You can type something up if you want, but it does have to be signed and dated. Okay. You can also handwrite it out on a piece of notebook paper, signed and dated. Put it with your documents. Your documents, whether it's a will or a trust, reference that personal property memorandum and say, first, give the items to the people named on that memorandum. And then there is a provision in your documents that says, well, what about the other stuff? Because maybe I said who gets my toaster, but I probably didn't, right? So I probably have all this other stuff. I won't call it junk. I had a client, I used to call it junk, and then I had a client say, mine's not junk. And I said, okay, mine's junk. But other people's may be very valuable, but all the other junk that's around, my socks and my towels and my toaster, will say, that just goes to the remainder of the beneficiaries. Or maybe we gave them a system and told them to draw names from a hat to figure out who goes first, and then they take turns choosing items until nobody wants anything anymore. That's usually the first thing that's dealt with is the stuff, right? And luckily, we do see a lot less fighting about that than we used to. And that's just because the nature of our stuff is different. Nobody wants my couch. It's 5 years old, right? But that's just different than it used to be. Erica, do you see a lot of people still fighting over stuff?
Nope. Although we do have specific language in our trusts if they are not agreeing how, in our wills, if they're not agreeing how to divvy it up, then there's a process. So I think that's very helpful. But yeah,
Okay.
the bigger battle is that nobody wants anybody's stuff. And that seemed to be the theme this week is people, I said, go use it yourself. As we decided, this woman and I decided she was just going to start using the crystal that her mom had given her because her kids don't want it when she's dead. I'm like, yep, just use it. Get it out of the cupboard and use it.
Yeah.
And no,
Yeah,
I don't
even
want it
the
either.
yeah, the china, the people will take the silver, but the
Oh,
crystal, the
I'm not even sure
china,
they'll take the silver.
you can
Anyway,
sell the silver, but
different world.
yeah, it is. It is. I'll never forget. I had a client a long time ago, and she did not have any children, but she had a lot of nieces and nephews, and she was very well traveled, and she had a lot of what she considered her treasures. And so she invited all of her nieces and nephews over for a very nice luncheon, and she had all of her stuff out, and she said, I want you all to know how much I love you, and please feel free to let me know what you would like, my African masks, my Chinese art, all of that. And they all basically said, we don't want your junk. She came back to me after that meeting and disinherited all of them, took them all
Oops.
out. They didn't know that her estate was, upwards of $10 million, and probably they shouldn't have offended her like that. She left it all to charity. So, you also want to be very careful to
Yeah,
not offend people.
take it, and then you can do what you want.
Yeah,
It is a
exactly.
touchy topic.
It is. It is. Okay, so I want to talk about estate taxes. This is one of the big changes that happened earlier this year. And so, as part of new legislation, right, Erica? As part of
Yep.
new legislation, now our estate tax exemption amount is going from 13.99 million, which is what it is this year, up to 15 million next year, and that's permanent. It will continue to be indexed for inflation after that, okay? And anything over that amount is going to be taxed at 40%. So, a lot of this is confusing to a lot of clients because I have a lot of clients who, when their parents passed away, they had to pay estate tax bills, and they can't believe that there won't be an estate tax bill. What you need to remember is that back in the 90s, for example, when I started practicing, the estate tax exemption amount was $500,000. Now it's $15 million. That's a big change, right? And so a lot less people have to worry about estate tax, which is a good thing, right? And so only if your estate is over $15 million going forward in the future will that be an issue. One of the big concerns was what was going to happen with this, because this law, the current law that we're under, was scheduled to sunset at the end of this year. And so we have all been waiting on the edges of our seats, right? I know Erica especially has been on pins
Oh,
and needles, just
barely
waiting.
sleeping.
I know. And so then when they passed this legislation, we said, oh, okay. All right. So now that's our solution. So We have probably been talking to some of you for years saying we need to see what's going to happen with the estate tax. This is it. Big drum roll, right? This is the answer. Now we know it's not going to go back down to $5 million. Dollars. We're going to be at $15 million. Dollars. So that answers um, the potential issues for a lot of people. Okay. Now, the other thing to remember with the estate tax is that there's what's called the unlimited marital deduction, and that means that at the death of the first spouse, everything just goes to the surviving spouse without any taxes. Taxes are due at the second death. Okay. When we have a married couple and they have an estate tax issue, then you would have done what's called an AB trust or a bypass trust. And that is this fun diagram. So, for those of you who like diagrams, as estate planning attorneys, we like to draw, right? So, you would have seen us draw out this little diagram where at the death of the first of you, it splits into two separate trusts, right? Like this. That's what we do when we have estate tax issues. So the way that that works is, let's say in this case we have Bob and Barbara Smith, right? Bob's estate is $7 million, right? His 2025 exclusion amount, meaning how much he can leave tax free, is $13.99 million. What he would have said in the trust document is that that amount is going to go into his credit shelter trust, meaning it is now sheltered from estate taxes. What's in that trust still pays to the surviving spouse for health, education, maintenance, and support. And that's a standard that allows for the surviving spouse to use that money for their basics, not luxury, but for their kind of basic average stuff. And because there's that limitation on it, it is then no longer included in the surviving spouse's estate at death. So it shelters that money so that then when Barbara passes away, all that's included in the value of her estate for tax purposes is what's in her trust. So that family trust is, I'll kind of go back here. That family trust, that credit shelter trust is typically called the family trust. Okay. So that can take up to the maximum estate tax exemption. Again, this year, 13.99 million, next year, 15. And that says it pays to the surviving spouse for health, education, maintenance, and support. Now, one thing about this is that whenever you are trying to avoid estate taxes, you have to jump through the hoops. It's a lot more complicated. So there's a separate tax return that has to be filed for that trust. There are rules for how that money is managed. The spouse can be the trustee, right? But that doesn't mean they can just do whatever they want to with the assets. Okay. There are other reasons other than estate taxes to use a family trust, and some of those can include creditor protection. So if the assets are in the family trust or AB trust, that then they're not subject to creditors, lawsuits, divorce. So when we do have clients that are concerned that after they've passed away, that their spouse might remarry, that might be something that we talked about so that assets would be held in that trust. And because there's limited use of those assets, they can then be protected in the event of divorce. The other thing that it does is it makes sure that when a married couple put their plan together in the first place, that then after the first spouse has died, they know that their assets are still going where they originally planned. Okay. So the fear is that sometimes one spouse passes away and the other spouse can change the plan, right? And leave the assets to whoever they want or cut out the spouse's children. And so that's the other thing that a family trust can do is it can allow that protection to know that that spouse's children are always still going to be included. Come on. There we go. Now, the other trust in the AB trust is the survivor's trust, and that trust is a lot more flexible. It has the surviving spouse's assets. Sometimes in the world of estate planning, things do make sense, right? The surviving spouse's assets go into the survivor's trust, and that trust pays out income and principal for whatever the spouse wants. Generally, well, mandatory income, but discretionary principal for whatever they want, and they still have the power to amend or revoke that. Sorry, the computer is fighting with me. Um, Now, a lot of clients, when we don't have concerns about estate taxes, then we're doing a plan that's called for a non-taxable estate, or sometimes we call this a simple trust. And that basically just is that example that I went through right at the beginning, where at the death of the first spouse, everything is held in trust for the surviving spouse. And typically, the surviving spouse is still the trustee, can use the assets however they would like. It does not require a separate tax return, so it's a lot more simple, easier, right? And then there would be specific rules for whether or not the spouse can continue to amend or revoke the trust and what they can use those assets for. But a lot of times this is a lot more of a loose distribution to the surviving spouse. And this is typically done when we're not concerned about estate taxes. But if the amount did go over the estate tax exemption amount, then that would be subject to estate taxes at the death of the second spouse. So at whether you do the AB trust or the simple trust at the death of the second spouse, right? The what the trustee is going to do first is they're going to look at the assets, look at the documents, and figure out where are the accounts. And then they're going to look at the personal property and they're going to give those items out to those people that are named. And then with the remaining items, they're going to sell or donate them, right? They have to do something because somebody has to still clean out the garage or the basement. And if you're like me, there's a lot of stuff in there that really nobody wants. So you got to deal with it because you have to sell the house probably, right? So you figure out the personal property and then you start figuring out what the debts are. This can take time. Medical bills in particular, they don't come in right away, right? They take time. So when beneficiaries are really anxious to get their inheritance, it's important to remind them that it's going to take a little while to pay the expenses and the taxes. There's a lot of moving parts there. But it's all paid from the trust, from the estate. And once the bills and taxes are paid, then either the family trust and the survivor trust come back together, or if it was a simple trust, then all the assets are there. Then you look at the trust document and you say, aha, now who inherits, right? And you give the assets to those people. If it's an unmarried couple, right, kind of the same thing. You distribute the tangible property, pay the debts. Normally there's a share for a survivor and there will be specific terms. Is it in trust for them? Is it outright? You look to the document to see what it actually does. And then again, at the death of the survivor, distribute it out to whoever the trust says is lucky enough to inherit. For unmarried people, right, it's the kind of same process. You look at the document. First, you deal with the tangible property, then you pay the debts, you pay the expenses, and then you distribute the property to whoever is lucky enough to inherit, right? Sensing a theme here, just always remember that bills and taxes get paid first. And that's really important because if you distribute all the assets out, right, because the beneficiaries are pressuring you, what would happen at that point, Erica, if you've given away all the money and then it turns out you owe a whole bunch of money to the IRS or somebody else?
Uh, I'd say that's a big problem. Just for the
Yeah.
sake of time, I'd say bad.
Yeah, it's not good. You're basically responsible. You have a duty, right?
Yeah.
Fiduciary duty. All right. So when it comes to distributing the assets to the kids, you have a couple of options, and it just depends on what the trust was set up to say. The trust might say that you give everything outright to we say children a lot here, but beneficiaries, whether that's your children or nieces and nephews or siblings or whoever it is, right? It
It's
might,
whatever.
yeah, it might just say give it to them outright, or it might say, put it in trust for them and distribute it out over time. Like Erica mentioned for her great niece, for my stepdaughter, right? A 17-year-old child, you don't want to give them a whole bunch of money. So you say it's in trust to be used for their benefit. And when they turn a certain age, then they get the money. Or maybe different ages, they get the money. Or maybe they never get the money and it stays in trust until they die and it goes to their children. And there are different reasons to do that, whether you're trying to protect them from just being young and somebody taking advantage of them, or perhaps you're trying to protect the assets in the event of divorce, or if they're in a high liability profession like a physician or something like that. So that's something that you would have talked about with your attorney in terms of how you want to set up those distributions. The trustee, always remember, is the person who is in control. And so, as a trustee, if you are named as a trustee in a document, your job after you've paid the bills and filed the taxes is you have to manage those assets, which means they have to be invested appropriately, right? So nothing crazy, vested appropriately. And then it's your job to make distributions to the beneficiaries based upon what the trust document says. You don't get to decide, right? The trust document will say distribute for healthcare, education, maintenance, and support. So there'll be times where you have to say yes and no, right? If my trustee is holding trust money and trust for Erica, and Erica says, I'm sorry, but I have to have the Ferrari, they're going to say, you don't need a Ferrari. You do need transportation. How do you feel about a Toyota, right? It's not a Ferrari, right? That's the
Beth,
trustee's job, is
we
to
had a
say yes
question
and
here,
no.
Beth. Sorry to interrupt. Can more than
Yeah.
one person manage your trust? I know the answer to that is
Mm,
yes. Like, could you have co-trustees? The answer is yes. Is
yeah.
it a good idea?
Depends. I think it really depends.
No.
Sorry to be lawyers about it, but
I'm going to say no, but you say it depends.
yeah, and again, different lawyers, different opinions. It depends on how they get along. Depends on where they are in the country. Sometimes more cooks in the kitchen is just more work. So it really does depend. But every family is different.
Thank you.
Come on. So what we always tell clients is, when it comes to a trust, it's going to be less expensive after your death than doing that full probate, right? If it's a taxable estate, yeah, there's still going to be work. There's stuff that has to be done, but it's usually about half the cost of what a probate would be. If it's a non-taxable estate, it's generally a pretty simple process. That being said, again, if we don't expect your trustees to know exactly what they need to do, the most important thing that they need to know is where your documents are, that they're in charge, and that there are resources for them when it comes time to having to do this. And they should talk to somebody. We give a free 1 hour consultation. We're going to say to them, wait, don't distribute the assets yet. Pay the taxes first, right? If they don't know that, they can really mess them up later. And so tell your beneficiary or tell your trustees that they should get assistance. That's what people are there for. And the taxes are generally the hardest part. And there's a lot of nuance there. I won't get into all of that, but there's a lot of nuance there in terms of when taxes have to be filed and certain elections made. It's important that they know that they should be talking to an attorney and to a CPA and all of that to get that advice. So again, the hardest part for a lot of people is figuring out where is the paperwork and where are your accounts. Don't make them piece it together. We've given you tools that will help them. In your binders, there's a tab that says location list. That's a place to list where you keep all your assets and paperwork, right? So that they know where it is. And if it's in the safe, like Erica said earlier, you're probably going to need to let somebody know the combination. We don't want the combination. Erica, do you want the combination to your client safes?
No. I have my own
No.
family to worry about. Nope.
Nope.
I don't want the combination. I don't want to know where your documents are stored. And I don't want your usernames and passwords. But who needs them?
The family, right? And
Or
we don't
whoever
want
you
your,
appointed, whoever you
yeah,
appointed to be in
whoever you
charge.
appointed. And we don't,
Passwords,
yeah, we don't
usernames.
have your usernames, your passwords. We don't have your account numbers. In fact, I don't even want to know what bank or financial institution you use, right? That's for you to give to the people who are going to be in charge. And so use those tools. And if you already have a system, fabulous. You're ahead of most of our clients. But tell them what your system is. Tell them that you have a notebook hidden in the bottom of your drawer, that you have a password protected spreadsheet on your computer, and then tell them what the password is because they need to find this stuff. This is, I'm not even kidding, the hardest part because people will come in to see us and they're already grieving. They've lost somebody they love. And I say, okay, what are the assets? And they go, okay, well, there's a house, there's a car, right? We can see these things. I know where they bank. And I say, all right, well, is there life insurance?
Oh, no.
I don't know. Is there a retirement account? I don't know. Is there a separate retirement account at their work? I don't know. Do they have stocks and bonds? Do they have more than one account? Do they have certificates? What do they have? And if they don't know, it's a lot to go through somebody's paperwork and figure that out. And I say paperwork because showing my age, but right, how many people have paperwork anymore? A lot of it's just on their computers. And Erica, if I call Microsoft and say, "Listen, I need the password to Erica's computer. She died and I'm in charge. Trust me." Are they going to get me into your computer?
No, no. if you do nothing else after today, you're going to make a list of some kind. You're going to convey this information to the people you've appointed. I don't care how you do it. And if you say, well, I don't want to write it down, then I'll say, figure out a way then. Just figure out a way. Don't come up with excuses and say, oh, I don't want it written down. I give a flash drive to my sister every year. Whatever works.
Yeah.
You'll
Whatever
figure
your
it out.
system is.
Google what's the best way? I mean, yeah.
There are those knock boxes people like.
You
You
don't
can
need
handwrite
to
your
spend
own
money on a
form.
knock box. Sorry, you don't need to spend money on
You
a
don't
knock
need to.
box.
Some
It's an
people like it.
empty
It's
box.
whatever you like. Just do it and then
Yeah.
tell somebody what you have done. And the usernames and passwords, I'm sorry, are just not optional. Your phone, right,
Oh,
is what we
yes.
call a gateway, but guess what? It's password protected. And if they don't know how to get into it, they can't find anything. What happens more and more
Yeah.
often now is that after a couple of years of inactivity, an account gets closed and it goes to the state of Colorado. So if Erica's in charge of my estate and she doesn't know that I have my secret rainy day fund at First Bank, so she doesn't call them, then after a couple of years, that money goes to the state of Colorado. Well, I don't want the state of Colorado to get that. I want it to go to my loved ones, right? So this is, if you, again, as Erica said, if you do nothing else from today, do this part. It's really important to help in the management of your estate. Mm, mm. I'm trying to get it to turn the page.
It just takes us.
There
I
we
know
go.
it's weird, crazy.
So, um, things from today, right? If you have a trust, is it funded? Do you have beneficiaries designated on your accounts? Look back at your documents. We would have given you advice on that. Okay. Um, do you need to change the terms of your will or your trust? Do you need to disinherit somebody? Do you, which I always kind of say jokingly. Well, I had a client last week who said to me, though, that maybe they would just casually leave their documents out on their coffee table when the kids come over to the page that includes the no contest clause, just to let them know that if they want to challenge something, that they would be disinherited. But, you know, do you need to change who's in charge? Maybe you set everything up 10 years ago when one of your, let's say your sister lived here and she was going to be in charge, and now she's moved to Africa. That might not work so well anymore. So you have to look at this from time to time. Things do change. And so if you haven't looked at it, please do look at it. Make this work for your family. You've done the hard work already. Just follow through on those other steps. A couple of other things, if you have moved, make sure that you update your information with us. We do send out newsletters to try to update you on changes in the law and things that are going on with us. We appreciate having your email address so that we can be in contact with you on those types of things, and reminders to, get in, review your plan, make sure it's up to date. And of course, we always have to say, and we so appreciate it, that if you have friends, family members, people who need help, we are here to help everyone else as well. We take a lot of pride in what we do, and we want to make sure that people have done their planning. We really, really actually believe in this. It's important. We've seen what happens when the planning isn't done, and so talk to your loved ones and make sure that they have their planning in place too. Especially if you're going to be the one who's in charge, it'll make it easier for you, a lot easier. Erica, anything else to add at the end?
Couple things in the Q&A, and if you need to go, we understand, folks. We appreciate your time. I'm going to cover these questions in the Q&A here, so hang out with us. If you don't stop the recording either, Cameron, please. Does having the home titled in the trust prevent the fraud we hear about people having the home title changed by criminals? Nothing stops criminals, Joe. I think it might make it an extra step harder, but literally these were people for forging people's names or coercing them into it. So we don't say the trust does anything to help with that, because bad guys are still going to be out there. So I wouldn't use a trust to try to stop fraud. You just got to learn about fraud and how to protect yourself. So I don't think it has a big impact there, Joe. Beth, when distribution of assets to children or whoever happens, do assets qualify for step up in basis?
Yes, the trust is completely transparent for tax purposes. And so, well, So yes, you still get a step up in basis. And if you have an AB trust or a credit shelter trust, there are some additional complications that I'm not going to go into with that. But yes, we generally have provisions in there that will allow for a step up in basis. If your documents were done more than, Erica, would you say that's 10 years ago when we started including the special power of appointment?
Yeah, but I wouldn't. I don't think this is an AB trust situation. So I would
Okay.
just say, look, when you die, you get the step up, right? It has nothing to do with whether you have a will or a trust. Is that true, Beth?
Yeah, generally, but if you documents were done more than 10, 12 years ago, it's probably time to review them anyways, and that's something that we would look at with you.
Okay, fair enough. Fair enough. I didn't mean to, but yeah, I think they were just talking about, yeah, step up.
Yeah, in general, yes.
Joe asked about covering a husband and wife using basically portability. Uh, Joe, I don't know that we're going to get into it because it's too complicated to kind of discuss, but if people have dealt with an estate tax situation, if people have over 15 million, 14, $15 million, we have definitely talked to them, our clients, about portability as an option rather than a bypass trust. But it allows one spouse to use the unused estate tax exemption of their spouse. But again, it's a little hard to explain in this context. So I'm going to, sorry, Joe,
Yeah.
punt on
It
that.
is
But it's
it
really
is
good to see you,
com
Joe.
yeah, it is
It doesn't affect
complicated.
most of our clients, and those that it does, we've definitely talked to them about it.
And the other thing I would just say is that might have been something that was a lot more of a concern when we thought that the estate tax exemption amount might go back down to $5 million. And now that it's up to $15 million, less of a concern. But it's a specific question, and if it applies to you, then that would be something I would say to talk to your lawyer about.
Uh, I think we did it. We've got everybody answered. We've got people still hanging on, but now, guess what, everybody? You get to go enjoy this beautiful, beautiful day. Those of you that are Bronco fans, go Broncos tomorrow. Very scary. Uh, and I hope you guys. Oh, what's a step up? A step up in basis is when I die, anybody dies, the capital gains that have been created within their assets, their house or their investment accounts, those capital gains are wiped out, and no one's going to ever have to pay capital gains taxes on that. So that's called a step up in basis for
It's a good
determining whether
thing. You
capital
want
gains are owned. It's a good thing, and it's law. It doesn't have to do with wills or trusts. It just happens. So thank you all. Thank you for the thumbs up and the.
Thank you, everybody. Sorry, when you have lawyers on a Saturday morning, we're talkers. And so, yes, we went a little bit over, so we
It was
appreciate
my
your
fault.
patience. As me too. I like to talk. All the words, all the
All the
words.
words. We love our words. So thank you for attending. Thanks for letting us run over. We appreciate it. Have a great, great rest of the weekend. Okay.
Thanks, everybody.